We began our study of the Mishnah in the 10th parak of Yevamos, Ha'isha Rabban Daf Pei Zayin Amid Beis. Let's go over very quickly what we did yesterday. Ha'isha Shalach Bailam Dina Sayam, Ubo V'Amrula Meis Balech, and we'll see later on whether it was two witnesses or more likely one witness. V'Nises, and she got married. And it would seem that although she relied on one witness, that's not sufficient, and she deserves a penalty because achakach ba baile. So she should not be relying on the testimony of one witness. She should be seeking out further evidence before she decides to get married to a second man. She didn't do that. She simply naively said, okay, I'm relying on one witness. The halacha, the Torah doesn't rely on one witness. There could be cases where the Torah relies on one witness when we have, number one, very strong evidence to support the one witness. And number two, when we know that she did her due diligence and she ran around collecting, all sorts of bits and pieces of information until she finally had enough evidence to clarify that her husband did in fact die. But in our case, she failed to do so. And she got married. And the Mishnah says, if the achakach ba baila teitze mizeh umizeh, not only is she prohibited from the second husband, and that's crystal clear because that was a case of adultery. And the Torah says, v'nitma'ah, that in a case where she had tumas arayos, she can no longer remain married to that man with whom she had that affair, that relationship. But even the first husband could not remarry her because once she had the extramarital relationship, then teitze mizeh mizeh, and that's called tamei lebal uleboel, echad lebal v'echad leboel. That a woman who had a relationship out of marriage is prohibited both to the boel, he's not going to gain from that relationship, and to the baal as well. So that's called teitze mizeh umizeh. Now we go on to other ramifications in this case. Utzricha get mizeh umizeh. If you recall, this was a pretty revolutionary idea. She's not married to the second husband. No way, no how. Her first husband's still alive. You can't marry a Masechet Yevamot, a woman is married. But yet the Rabbanan will recognize the marriage to the second one such that she cannot get, it's not sufficient that she receives a get from the first husband and then go ahead and get married to someone else. She requires a get from the second husband as well. And we are recognizing the marriage to the second husband, because we don't, then the spectator will think that the Rabbanan condoned a marriage, the third marriage, when she never got a get from the second husband. Therefore, we recognize the issues to the second husband, and she will not be able to marry anyone without a get from the second husband. He says in the footnote here, I'll just read this to you, but I think we had it on our own. The get from the first husband is d'oraisa. The get from the second husband is only d'rabbanan. Okay. And this is what we got up to yesterday, the part of Masechet Yevamot that overlaps with Masechet Ksubas. V'ein ksuba, lo al zeh v'lo al zeh. Normally, when a husband divorces his wife, the get is accompanied by the payment of the ksuba. The ksuba is given at marriage under the chuppah from the husband to the wife. She holds on to the ksuba as a document, which is like a loan, but a conditional loan. It's not an absolute loan. Normally, a loan only needs what's called sofzmano, and the time came for the borrower to repay the lender. But in the case of ksuba, there's an extra condition in the ksuba, and that is that she collects the ksuba in event that he, the husband, divorces her, or in the case where he dies, she collects the ksuba from his estate. And ksuba is an institution that was accepted and validated by the Rabbanan to protect the rights of a woman in marriage. That in event of a divorce, she should be protected by the ksuba. To collect masayim zuz or meya zuz, depending upon whether it's a first marriage or a second marriage. And the ksuba will be valid if the chachamim want the marriage to continue. In a case of an adulterous relationship, the Rabbanan want to terminate the marriage. Teitze mizeh mizeh. She can no longer return neither to the first or the second husband. And this is a penalty for her, because she wasn't careful before she got remarried. The second guy. Here, she has no rights to ksuba. Her actions invalidate her or undermine her rights to collect the ksuba. Not from the first husband and not from the second. Below payros, below mizonos, below blows, lo alzeh, velo alzeh. All her rights to the ksuba, like for example, mizonos. The ksuba institutes that a husband must support his wife. In this case, she has no rights to demand support because her actions that led to an adulterous relationship indicate that she has to be penalized and has to forfeit her rights to the ksuba, not only to the collection of the ksuba itself, which is masayim, but also to the collection of any rights that accrue to her as a result of the marriage, because those rights are codified and etched in stone in the ksuba in order to protect those rights. We're not going to protect her rights in the ksuba when she forfeited her rights to the ksuba by having this out-of-marriage relationship. And now we can begin to understand velo payros. What does that mean? Normally, in a marriage, the ksuba gives rights not only to the woman, but also to the man. It's a quid pro quo kind of relationship. For example, the ksuba establishes, the Mishnah in Masechet Ksubas, that in event that she was taken captive, he, the husband, will have the responsibility to gather together the funds to ransom her. And as a result of the husband's responsibility of pidyon, in case that she fell to Shevi, we give him rights quid pro quo. It's not all her rights and impose upon the husband all these financial responsibilities. We have to give him something in return. And we'll give him what's called payros. And in the case of Nitzei Mulut, she came into the marriage and she has an apartment, let's say, or a field, a grove of oranges, and the apartment is bringing in rental, or the grove is producing oranges. We give the Baal, in the framework of Ksuba, rights to pocket that money, the increment and the interest, so to speak, the benefits from her nechas. And that's a right that's given to him because he's taken upon himself, like it or not, because that's what he did, he signed on to the marriage, the responsibility to be poda her in event that she's captive. But now that we're removing her ksuba and the rights therein, he doesn't have the rights that were given to him quid pro quo because of his responsibility vis-a-vis his wife. And therefore, he has no rights to the parents. And I'll read to you the Ritva in its English translation. He says, since we regard the woman as an adulteress, she forfeits her rights to be ransomed by her husband. And accordingly, her husband is not going to be granted and entitled to the produce of her property, which is given in exchange for his obligation to free her from captivity. Now, in the case of the second marriage, which on a Doraisa level is void, the second husband never had rights to Peros. The Rabbanan never established rights to the second husband for Peros if he was never legally married to her. So for sure, therefore, both the first husband and the second have no rights to Peros. The real chiddush is that the first husband doesn't have rights to Peros because he has no responsibility to redeem her from captivity. Now the issue is going to be, what about the Peros that were already collected by each one of these two husbands until we found and discovered that her first husband was alive? So let's say, for example, the Nichsei Malug have Peros that have been going into his bank account, whether it's the first or the second. Now we find out that there is no rights whatsoever for the Baal to collect Peros. Does he have to cough up at least the value of those Peros that were already consumed? And here we can make the distinction between the first husband and the second husband. The second husband never had rights to Peros. And therefore, if he ate Peros, he has to reimburse her for the Peros that he ate. But in the case of the first husband, he had rights to those Peros. And if he consumed that benefit, then what claim could she have that Lemafreya retroactively should have to pay and compensate her for the Peros? And therefore, the Mishnah is talking Mikanu Lahava, from this moment and on. Henceforth, he, the Baal, will not eat the Peros. The ksuba is now invalid. The marriage has to be terminated with a get, and those rights that the Baal has to collect Peros through the ksuba, rights that were established by the Rabbanan quid pro quo because of his responsibility to free her, he's alleviated from those responsibilities because the ksuba is no longer valid, and therefore he doesn't have rights to Peros. So from now on, he cannot collect Peros. And now we get to Mizonos, which we said before. She has rights to collect support, but only if the ksuba is valid. Now that we want to force a divorce, we're not recognizing the issues as a viable issue. So it has to be terminated with a get. She no longer has rights to Mizonos. Here in the note, do you have the English? No. Okay, if anyone has the English, I think, Dawn, maybe you have the English. You can take a look at number 9. He writes, it goes without saying that she forfeits her right to collect bizonos and support once her husband reappears, because his obligation is to divorce her. So there's no claim of haksuba that she could say, support me. When on the kasha, the halacha says we need a divorce. However, here's the following scenario. Her husband originally went abroad and he did not provide for her. There was no money that was earmarked in the bank account for her support. She borrowed money in order to support herself under the assumption that when he returns, he will pay back those debtors because it's his chiyuv to support him. However, in this case, where she took loans to support herself, the Mishnah is machadish an unbelievable chiddush. He, the Baal, when he returns alive and well, does not have to pay and reimburse all those balei chov from whom she borrowed money to support herself, even though during this period of time he was obligated to support them. He should have set aside money before he left on the big voyage to support her. And if he didn't do so, then any money of support should be obligatory upon him when he shows up. And that money is now coming from the various Malvim who lent her the money. He should be paying back those Malvim for that period of time during which he was obligated to mizonos. She didn't have mizonos. He didn't provide that money for her, and she had to take loans. Again, if you ask me about the second husband, does he have to pay back these debts? I would say that's obvious. He doesn't have to pay back these debts. He doesn't have any obligation to support her because the marriage was never valid. But the first husband should be paying back these debts in lieu of the support that he didn't offer her. And the Mishnah is machadish that we're going to penalize her, and any rights that are written and anchored in the ksuba, like for example, a right to mizonos, are completely null and void. And now we get to belos, which literally translates as worn out garments. Now, a woman brings garments into the marriage, right? Her father had bought her a wardrobe. Those garments are called nichsei tzon barzel. Now, nichsei tzon barzel, by virtue of ksuba, belong to the husband. But at the time of the ksuba, they evaluate the nichsei tzon barzel. They give it a price tag, a market value, and that value is written in the ksuba. And that's the value that the Baal will have to pay her in event that they terminate the marriage. That's called nichsei tzon barzel. So her wardrobe that she brought in from her father's house into the marriage, that's all nichsei tzon barzel. And we evaluate it at X, and that's what the Baal is going to pay. It doesn't matter if these nechas went up in value or down in value, more likely down in value over the course of time, but nevertheless, he's got to pay the original value as it was inscribed in the ksuba when they did a shuma and they evaluated the nichsei tzon barzel. Now, this word belos is a bit ambiguous because the implication of the word belos sounds like during the course of the marriage, these articles of clothing got worn out. Now, if a woman collects a ksuba, so obviously, as we said before, she collects nichsei tzon barza, which is the sum that's written in the ksuba. Fine. But now the Mishnah says below blows. What does it mean below blows? L'chora nichsei tzon barza have nothing to do with blows. You're combining two concepts that are irrelevant one to the other, because nichsei tzon barza is a financial obligation that's set in stone. It's set in the ksuba. What do I care if the clothes are worn out? So the choice of the word blows here has the following implication. We're going to penalize her, and the blows are returned. They now belong to the first husband. She can no longer say, well, the blows themselves have some sort of market value as markdowns, but they have some value. Give me back at least the value of these begadim. So that in nichsei tzon barza, with the termination of the marriage with a get, the ksuba says that he will get the nichsei tzon barza. He'll pay the original value of the nichsei tzon barza within the framework of the ksuba. But she is now saying, fine, you don't want to give me the original money of the nichsei tzon barza that was evaluated and assessed and written in the ksuba, that I forfeit. But at least the worn out garments that have a value, I want to get reimbursed for them. The answer is no, she can't get reimbursed for them. Why? Because they were written in the ksuba as nichsei tzon barza, which means that if and when the marriage terminates, all those nechasim accrue to the baal. He owns those nechasim. Normally, if she was not penalized, he'd have to pay her the value as it was evaluated at the time of the marriage and written in the ksuba. Those rights she's forfeited. And therefore, he now owns the nichsei tzon barza without having to pay for them. Normally, nichsei tzon barza is a kind of a swap. It's almost like a barter exchange. With the get, he pays the value of the tzon barza and he gets the nechasim. And if they went up in value, he did a good deal. If he went down in value, it was a bad deal for him. In this case, he gets his cake and eats it too. He will continue to be the owner of the nichsei tzon barza by virtue of the ksuba, but he doesn't have to pay for the nichsei tzon barza. And therefore, in the case of one-out begadim, that's the Mishnah's chiddush, he owns the one-out begadim. She has no right to demand its value because it's nichsei tzon barza, and therefore there was already a transfer of ownership from the beginning of the marriage. You'll say, well, if you're treating it nichsei tzon barza, then he should have to pay that, as it was evaluated at the time of the ksuba. The answer is there is no ksuba. She forfeited a ksuba, and therefore he doesn't have to pay the value that's written in the ksuba as nichsei tzon barza. V'im natla mizeh u'mizeh tachzir. If, let's say, she grabbed the money, she went into his, the dresser or wherever he hides his cash, and she took the money in lieu of payment of her zonos. She wants to pay back her bali chov, or she took the money thinking that she has rights to the value of the blows. She took the money of the payrolls, the rental agreement, rental fees. She grabbed it. She doesn't want to give it up. Even though normally we say Amotzi Mechavel Varaya, in this case, we will force her to cough up any monies that she took because those monies were taken illegally. and therefore tachzik. Now, what's the status of a child that she had from the second husband? Certainly he's a mamzer. I don't need the Mishnah to teach me. But the Mishnah says, Havlad mamzer mizeh umizeh. Not only if she had a child from the second husband, but if, let's say, the first husband, when he shows up, they get together again for another intimacy and she becomes pregnant, the child of that intimacy is a mamzer, which is mind-boggling. Because on a Doraisa level, this is her husband. The Rabbanan said that because of Tumah, she had an extramarital relationship, she can no longer go back to the first husband. But would that generate mamzerus? And the Mishnah says yes. Now Rashi says here that the child from the first marriage is a mamzer d'Rabbanan. What child are we talking about? We assumed, I will soon see that's the Maggid Mishnah. We assume that we're talking about a case where the husband, first husband, went back to her and she conceived from the first husband. That child would certainly be a mamzer d'Rabbanan, because on a Doraisa level, she's married to the first husband. And he writes here, the child that's married, that's born from the first husband after his return, is a mamzer d'Rabbanan. That makes a lot of sense. Because as we said over and over again, Minaраisa, she's married to the first husband. They cannot be mamzeres from the first husband. So the Rabbanan instituted mamzeres because they recognized the second marriage, and there's Ishus d'Rabbanan. Now the child is a mamzer from Ishus d'Rabbanan. However, here we have an insight of the Maggid Mishnah. What's the status of a child if the second husband gave a get, and now the first husband had a relationship with her after the get was delivered from the second husband? Would the child be a mamzer? We were talking about a case where the first husband had a relationship with her before she got a get from the second husband. And since the Rabbanan recognized the Ishus, the marriage relation to the second husband, the child is a mamzer b'Rabbanan. But what happens now if the second husband gives her a get? She's not allowed to go back to the first husband. That's called Teitze Mizeh Umizeh. And she went back and had a relationship with her first husband. Would the child be a mamzer? And the Maggid Mishnah goes even a step further. He says, what happens? She has to get a get from both husbands. In the following scenario, the first husband gave her a get. The second husband did not give her a get. And he had a relationship with her. On a Doraisa level, for sure, the child is not a mamzer, because the first husband, before she had this relationship with the second husband, gave a get. On the other hand, the Rabbanan said that she's not allowed to have any relationship with the second husband. She violated that Isa. Would the child be a mamzer d'Rabbanan? Unbelievable how the Maggid Mishnah went so far to explain mamzer mizeh umizeh. there could be a double chiddush here, Mamzer Mizeh Mizeh. Number one, it could be that the child is a mamzer from the first husband, even though she's married to the first husband. And not only that, it could be that the child from the second husband is a mamzer even after she received the get from the first husband. That's how far we're going with mamzer mizeh mizeh. Now, the next part of the Mishnah, which we'll leave in Mitzvah Shem for tomorrow, is really about Kohen. As you know, a Kohen is not allowed to be matami himself to a dead body, to a corpse. However, what's the deal in a case of a husband who never lost his wife, and this husband is a Kohen? And the Mishnah is going to establish that lo zev zev matamim, that neither of the two husbands are obligated or permitted, even because they're Kohen, to bury him. Why not? Okay, in the case of the second husband, that's not a valid marriage according to Torah law. But in the case of the first husband, what happened to the law of and the responsibility of him to bury his wife, even if he's a Kohen? All right, then that's what Linetta will pick up tomorrow. Wish you a great day.